Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover rules of court. Rule 116, Arraignment and Plea. Section 1. Arraignment and Plea. How made? A. The accused must be arraigned before the court, where the complaint or information was filed or assigned for trial. The arraignment shall be made in open court by the judge or clerk, by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. The prosecution may call at the trial witnesses other than those named in the complaint or information. B. The accused must be present at the arraignment, and must personally enter his plea. Both arraignment and plea shall be made of record, but failure to do so shall not affect the validity of the proceedings. C. When the accused refuses to plead or makes a conditional plea, a plea of not guilty shall be entered for him. D. When the accused pleads guilty, but presents exculpatory evidence, his plea shall be deemed withdrawn and a plea of not guilty shall be entered for him. E. When the accused is under preventive detention, his case shall be raffled, and its records transmitted to the judge to whom the case was raffled, within 3 days from the filing of the information or complaint. The accused shall be arraigned within 10 days from the date of the raffle. The pre-trial conference of his case shall be held within 10 days after arraignment. F. The private offended party shall be required to appear at the arraignment, for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. In case of failure of the offended party to appear despite due notice, the court may allow the accused to enter a plea of guilty to a lesser offense, which is necessarily included in the offense charged with the conformity of the trial prosecutor alone. G. Unless a shorter period is provided by special law or Supreme Court circular, the arraignment shall be held within 30 days from the date the court acquires jurisdiction over the person of the accused. The time of the pendency of a motion to quash, or for a bill of particulars, or other causes justifying suspension of the arraignment, shall be excluded in computing the period. Section 2. Plea of guilty to a lesser offense. At arraignment, the accused, with the consent of the offended party and the prosecutor, may be allowed by the trial court to plead guilty to a lesser offense, which is necessarily included in the offense charged. After arraignment but before trial, the accused may still be allowed to plead guilty to said lesser offense, after withdrawing his plea of not guilty. No amendment of the complaint or information is necessary. Section 3. Plea of guilty to capital offense, reception of evidence. When the accused pleads guilty to a capital offense, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea, and require the prosecution to prove his guilt and the precise degree of culpability. The accused may present evidence in his behalf. Section 4. Plea of guilty to non-capital offense, reception of evidence, discretionary. When the accused pleads guilty to a non-capital offense, the court may receive evidence from the parties to determine the penalty to be imposed. Section 5. Withdrawal of improvident plea of guilty. At any time before the judgment of conviction becomes final, the court may permit an improvident plea of guilty to be withdrawn, and be substituted by a plea of not guilty. Section 6. Duty of court to inform accused of his right to counsel. Before arraignment, the court shall inform the accused of his right to counsel, and ask him if he desires to have one. Unless the accused is allowed to defend himself in person, or has employed a counsel of his choice, the court must assign a counsel de officio to defend him. Section 7. Appointment of counsel de officio. The court, considering the gravity of the offense and the difficulty of the questions that may arise, shall appoint as counsel de officio only such members of the bar in good standing who, by reason of their experience and ability, can competently defend the accused. But in localities where such members of the bar are not available, the court may appoint any person, resident of the province and of good repute for probity and ability, to defend the accused. Section 8. Time for counsel de officio to prepare for arraignment. Whenever a counsel de officio is appointed by the court to defend the accused at the arraignment, he shall be given a reasonable time to consult with the accused as to his plea before proceeding with the arraignment. Section 9. Bill of Particulars. The accused may, before arraignment, move for a bill of particulars to enable him properly to plead and to prepare for trial. The motion shall specify the alleged defects of the complaint or information, and the details desired. Section 10. Production or inspection of material evidence and possession of prosecution. Upon motion of the accused showing good cause and with notice to the parties, the court, in order to prevent surprise, suppression, or alteration, may order the prosecution to produce and permit the inspection and copying or photographing of any written statement given by the complainant and other witnesses in any investigation of the offense conducted by the prosecution or other investigating officers. As well as any designated documents, papers, books, accounts, letters, photographs, objects or tangible things not otherwise privileged, which constitute or contain evidence material to any matter involved in the case, and which are in the possession or under the control of the prosecution, police, or other law investigating agencies. Section 11. Suspension of arraignment. Upon motion by the proper party, the arraignment shall be suspended in the following cases. A. The accused appears to be suffering from an unsound mental condition, which effective renders him unable to fully understand the charge against him, and to plead intelligently thereto. In such case, the court shall order his mental examination and, if necessary, his confinement for such purpose. B. There exists a prejudicial question, and C. A petition for review of the resolution of the prosecutor is pending at either the Department of Justice or the Office of the President, provided that the period of suspension shall not exceed 60 days counted from the filing of the petition with the reviewing office. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.